Good morning, Ms. Hawkins.
This judge
Ma'am,
isn't
you're charged
wasting
with drug.
time. The charge? DWI, one of the most serious misdemeanors out there. And when he mentions 6 months in jail and a $2,000 fine, that's not scare talk. That's the real statutory maximum. Let's see how this unfolds.
Driving while intoxicated, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer
Buzzed but not drunk. That's a line officers hear in nearly every DWI stop. But legally, buzzed and drunk are on the same road, and that road usually ends in court. The judge will not be impressed by half admissions like this.
in contact with the defendant, the driver, and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search.
Here's the turning point. The judge just ruled probable cause. That means the evidence, like the tequila cup and her admission, is enough to continue the case. It doesn't mean she's guilty yet, but it locks her into the system. From here, bond conditions get serious.
Search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
It's just getting a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. Ma'am, you're not allowed to drive. I'm taking away your privilege to drive.
This is rare. The judge is showing genuine concern. He's not just enforcing the law, he's almost pleading for her to understand the gravity of what happened. Notice how the tone shifts from legal to personal. That's when you know a judge has seen too many tragedies.
You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that a standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting a lock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously.
Did the alcohol?
I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not absolute.
For Greg's purposes, since he's going to be the one representing her, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure.
What do you think? Is the judge being overly strict here, or just cautious? Should first-time offenders lose their driving privileges completely, even before lab results are back? Drop your thoughts. This debate never gets old in DWI courtrooms.
That she's, addressing the issue. I mean,
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, But it's something that I've seen more and more, where there's alcohol in the car, and I would presume that you would know, especially at this age, that,
well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the DIM summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit. And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates. Come back and,
And just
Hey,
for
you
purposes, so I can convey this debate. What's proactivity to the court?
just be creative.
Okay.
Be creative. And, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, I'm not asking for much. And once we know that there's appreciation, then let's talk again. Like I said, it's not long, Aaron, but I need to know. Now, well, because you have a lawyer, I will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with counsel and they will tell you if and when you have to come back to court. Do not pick up any new cases. Don't consume anything illegal or any kind of alcohol, and we'll be fine. You've got a great lawyer. Listen to them. They'll take care of you. I'll have you come up here, swear test. You're not going to drive for now. We'll have you sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and then you're free to go.
Thank you, Judge.
Thanks.
Your Honor, this is his aunt. The grandparents are outside, but she has a young toddler, so the grandparents are watching the toddler. But she knows the situation. She's,
Hi, how you doing?
Thank you for coming.
Come on in. So I've explained to the judge his current situation with him living with the grandparents in Victoria and how you guys are supporting him. We have this time served deal that the judge is considering so that, we can wrap up this case so that he can move back home, work for the family, go to school, everything that we talked about.
Yes.
He just always wants to make sure that as a young person, he has support. He knows exactly what's facing him before we do anything that he can never get back. So this plea that he wants to do, it's got its pros and cons that we talked about. So that's why the judge asked me to bring you here so that if you have anything to add or anything, so that he can consider it, so that he can make up his mind whether or not he's going to let Diego take the time served deal.
Okay.
Please, just tell me about, would he be approved for the PTI program?
He's already been approved for that, Judge. It's a 1-3. I've talked to him at length about that. It's just something that he and his family does not feel that they can accomplish with all the.
Because he can't stay clean.
Judge,
That's it.
they have some financial difficulties. So anyways,
Money is of no difference. I could care less about the money. When you take,
well, on a PTI program, Judge, I know you don't on defers and stuff like that, but on PTI, there's not a lot of.
That line, "You're going to pay for it one way or the other," says it all. The judge isn't just handing down legal advice, he's giving life advice. The system gives second chances, but it won't wait forever for someone to take them.
Besides the $300 DA fee. That's about it. In terms of the machine, in terms of monthly, they're pretty rigid by that. So I know you feel differently and your deferred is, but PTI is just,
that's complete.
PTI is just a hard rock, Judge, especially for economical reasons. Anyway.
I know back when I was staff division too, I had to tell It's like,